Hello again. This is a companion video to a blog I wrote in September 2024. In English criminal trials, there are recognised categories of prosecution evidence which are considered especially hazardous. That is, they have been recognised as having a particular tendency to mislead in a way that has been known to cause miscarriages of justice. The categories usually considered hazardous are 1. Eyewitness identification evidence. Ever since Adolf Beck's case in 1896, it has been understood that honestly mistaken eyewitnesses could appear very convincing to a jury. Number 2, evidence of lies told by the accused, especially if not material to the case, can be unfairly prejudicial. And number 3, confessions, in certain circumstances, can seem convincing but may not be as reliable as they seem. These areas of evidence against accused defendants share the common theme that juries will often not be aware of the many reasons these forms of evidence can be particularly unreliable and may find them inappropriately compelling. I would make the controversial and perhaps antagonistic case that this list should be expanded to include misleading or fallacious speeches or argument by counsel, not merely on the law, but on logic and fact itself. Post office trials. There are not many transcripts of cases available online where the accused was convicted but later shown to be innocent. As things stand, I imagine the trial of Seema Misra, former sub-postmistress, is likely to be the only example. Therefore, with apologies to the innocent Mrs. Misra for dragging the whole thing up again, there are points of the cross-examination of her and of the prosecution's speech that illustrate the point. Somewhen around 2010 or 2011, I heard about the Seema Misra and Joe Hamilton post office cases. Joe Hamilton appeared on Radio 5 and explained how the post office wrongfully prosecuted her, and that her own solicitor persuaded her into pleading guilty to something she didn't do, perhaps recognising the unlikelihood of her client getting a fair trial. I can't remember exactly how I first heard of Seema Misra, but I remember reading or hearing that she was sent to prison after being found guilty at a trial in similar circumstances to the prosecution of Mrs. Hamilton, and noted it seemed at the time extremely unfair as there was no evidence apart from a number on a computer. Years later, when these two and many other victims of the scandal had quite rightly been cleared on appeal, I found that the University of London had obtained the transcript of the Crown against Misra and made it available. Even leaving aside the Horizon computer side of things, elsewhere you can see the game the prosecution is playing. Here are the extracts I want in particular to talk about. Seema Misra is being cross-examined by the prosecution, and a CV for the job is being discussed. I just want to understand what you're saying about this, because you went through all the entries with Mr. Hadrill. You supplied this CV to the post office in support of your application? That is right, yeah. Is this CV meant to tell the truth? That is the CV what I've done. Yes, I know you've done it, but is it meant to be true? As far as I know, yes. Do speak up, I cannot hear. As far as I know, that is all I've done in the time period it stated. Were you trying to mislead the post office about your expertise? No. Warwick Tatford prosecuting is trying to obfuscate Seema's defence that even if money was missing, it never actually was, but she couldn't have known that for sure at the time of the trial. One reason could be that she made mistakes operating the system. This is an obviously correct defence to a charge of intentional theft, and one the prosecution had no evidence to disprove. They never found her in possession of the missing money, and never showed any positive evidence of anyone stealing it. But instead of directing a not guilty verdict due to this obvious hole in the case, the judge decided it was somehow fair to allow a patchwork of fallacies to be used to pretend to cover over the hole. Obviously Mrs. Misra doesn't want to say she misled someone in her CV in a theft trial. There was no evidence she lied, and no basis even to suggest the CV was wrong. Tatford, nevertheless, decides to put it in the way shown. Although what the barrister asks is not legally considered evidence, the jury is likely to come away from this wrongly persuaded that a lie has been exposed. He has also, probably correctly, reasoned that he can pull a Morton's fork, a fallacious argument where opposite pieces of information are manipulated into reaching the same conclusion. The suggestion is that if Seema had experience in accounting and using computers, she could not have lost money accidentally. It should be rather obvious that just because someone believed when applying for a job that they had the skill to do that job, and had experience, this does not mean mistakes are impossible. For one thing, the person may honestly overestimate their own ability. Secondly, the post office's computer might prove especially difficult to use, or especially prone to allowing mistakes. Third, it might be bad luck, or any combination of these. Despite confirming that the CV was true, Tatford decided to follow up with, "Mrs. Misra, a CV is relied upon by the person it is sent to. You are meant to tell the truth in it. It is the truth there. Like I'm managing my own business here, and I'm doing all whatever relates to in my business, I'm doing it myself." This does not appear to be a question, but he throws in another false implication that the CV may be untrue. Seema again confirms it is true. Tatford then later pivots to this. "Did you ever struggle understanding what the Horizon screen was saying to you?" "I stopped understanding it in mid-2006. "You didn't even bother reading it?" "No, reading it, understanding it, because when I could not find anything out, I stopped understanding it. I didn't bother to understand it, basically because I was in such a great mess." Lawyers claim cross-examination is testing a person's evidence. There seems to be little testing here. He asks a question, and when he doesn't like the answer that she had problems understanding Horizon, he misrepresents the answer by repeating back something entirely different in meaning, presumably hoping that the jury will remember his answer instead. When given time to go over this transcript, the deception is clearer. I've had time to look over this on several occasions, but in the courtroom, the jury could easily be misled by this. Tatford later turns to the allegations of problems in the Horizon operating system. He tests the evidence as follows. "You know perfectly well, do you not, that in relation to some of these things that you have read in articles, that the prosecution have looked carefully at other complaints, have they not? And you have been disclosed material in relation to Calendar Square, because that is an objective piece of material that gives a cause for concern about Horizon. You understand all that process, do you not?" "Yeah." As well as being a compound question, this is a misleading framing. The error in another branch is clear evidence of Seema's defence being true. The post office indeed did look at it and confirmed the problem in Falkirk occurred. But by introducing this statement with the words in bold above, he falsely implies the opposite. Seema has agreed to something which helps her case, but he frames it as if he's caught her in a lie by using the introductory and closing words shown. She has to agree because it is indeed true that she does know this piece of information that helps her is true. It's pure nonsense and sophistry. Tatford continues, "Thank you. So, is it a case of you jumping on a bandwagon when you read something that might give you a hope and adding a few extra false limbs to your defence?" "No, if you recall, in I think it was Mr. Dunks's call, I did make the calls on that, the losses as well, and when Chesterfield transferred me to Horizon, that..." He implies that this follows on from the last question, where Seema agreed to the confusingly stated claim that she knew the post office had found an error. The "so" here does not belong, because what Tatford says here is the opposite of what was just established. If he wanted to ask this, he could have said "nevertheless," or "in spite of that," or another word meaning the opposite of "so." But this would show it to be speculation and not supported by the previous question. Instead he bluffs and uses "so," like a child pretending his mum has just said yes instead of no to sweets. Is the art of being a barrister just to disguise these tricks? Let's now look at Tatford's closing speech. He makes the following bold and entirely wrong claims. "The Crown's case, as I open to you, is essentially a simple one. Put on one side all the detail you have heard, but this defendant cooked her books to hide a catastrophic loss at her post office, and the Crown say there is only one sensible reason for her doing that. She was stealing the money because otherwise it was in her interest not to hide things but to reveal things. If she thought thefts were going on, if she thought that she could not handle the equipment, she should have told the post office, and if she reported the thefts at an early stage, then maybe she would not be liable for that loss. It was in her interests always to be open and honest with the post office. There is no honest and sensible reason for fiddling the accounts, other than that she was stealing the money. Any other reason, the Crown say, is nonsense." I don't know if Mr. Tatford had instructions on the point in bold, but it is plainly incorrect. No evidence in the case supports it. When people were honest and open with the post office, they were routinely sued, bullied, sacked and prosecuted. Having failed to produce any real evidence of any theft happening, beyond money appearing missing on the computer balance, he's left with bluff. And Seema wasn't saying covering up the loss was honest, she was saying she didn't take any money. The defendant has taken the money, the Crown say, because she was the one who obscured the trail, who made things look to the computer like everything was fine. She has no reason for doing that whatsoever unless she is the thief, and her suggestion that she was worried about losing the post office is bonkers, because she was suffering catastrophic losses. She has no sensible financial reason for keeping hold of the post office. She has lost as much as she is ever going to get in a sale. She should have shut it down. He repeats essentially the same point before making the fallacious argument that because something was not a sensible choice, it could not have happened. Lots of things happen that are not sensible choices where people lose money. Even if we accept she should have shut the post office down, this is not evidence of theft, it is evidence of not making a sensible financial decision, which is not especially relevant to the issue in hand. I could pick apart the closing speech about computer bugs, but the point is more or less the same. Tatford wrongly emphasises how a computer problem would be visible to the user, ignoring that the effect of it here, missing money, plainly was visible, so visible it had to be covered up. He repeatedly makes several references to the calendar square bug, appears to acknowledge that it closely matches the symptoms in this case, before falsely declaring it irrelevant or a red herring for reasons that appear to be invented, either by himself, Gareth Jenkins, or instructions from the post office. The jury was apparently convinced by this. I might well have been too if I'd been there. The defender of the jury trial would say that this doesn't matter, because in a fair trial each side makes their arguments and the jury works out the truth. This is the theory, but I would make the case that it's a fantasy. The human brain is not fully rational and is littered with cognitive biases and reasoning errors. It's trivial to find examples of ordinary people being easily tricked into error by sophistry and logically unsound arguments. This is the basis for scams. Where jury trials probably have value is in assessment of things like consent, reasonable force, and perhaps dishonesty. If we continue to use juries as general finders of the truth, we should probably warn them clearly about, and perhaps protect them better from, dubious arguments along the way.
Ladies and gentlemen of this supposed jury, I have one final thing I want you to consider. Ladies and gentlemen, this is Chewbacca. Chewbacca is a Wookiee from the planet Kishik, but Chewbacca lives on the planet Endor. Now think about that. That does not make sense.